Mr. Peoples has not yet been referred to the forensic center.
Is he just going to remain in custody? Let the family do what they need to do. That's what you said.
I'm not disagreeing with that.
Stop talking. Childers, McDuffie, Mr. Brown, Miss Yagi, my change.
Things go from tense to completely out of control within seconds here. I've honestly never seen Judge Simpson react like this. He leaves the bench and calls in not only the prosecutor, but also the defense attorney and the chief deputy public defender for a private talk. It's clear he's had enough of the constant mistakes happening in his courtroom. The defendant in this case is clearly dealing with mental health challenges, and despite the family doing everything they can to support him, the system still seems to fail them. You can actually see the exact moment when Judge Simpson's patience finally runs out. When the state doesn't do its job, it's not just about missing deadlines or forgetting forms. It's real people who end up suffering the consequences. The frustration in that courtroom says it all. So, what do you think? Was Judge Simpson right to handle things this way? Or did he take it too far? Share your thoughts below while we break down what really happened here.
State your name, Sam.
Samuel Peoples.
Your Honor, in file 1326, Mr. Peoples has not yet been referred to the forensic center. I've prepared an order, and we are asking the court to order a forensic examination. In that case,
All right, I will order a forensic examination without objection. On that case, what is my next date? Let me see now. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just like last week.
That was last week. All right. So set a competency here, October 2025, 9 a.m. All right. What are we doing on the other case?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326.
Well, it also arose with Ted.
Which is charged as a felon, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's specific.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I thought anxiety.
Response?
Your Honor, obviously we had an extended conversation about this at bench at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that, given that we have this incident, I don't know how sufficient that's going to be, but I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're going to cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before you just did it?
I had a moment of anxiety that led to a freak out. Yes. And I felt like I needed to get it off me because it was claustrophobic. And
Got it.
yes.
I hear you. Okay. All right. Here's going to be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap. Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
Samuel,
Yes, Your Honor.
I give you another shot. You gotta try to do the right thing.
Yes.
Okay.
Thank you, Your Honor.
All right. I'm gonna do it. I think you can do it.
Me too.
Okay.
All right.
Yeah.
Thank you.
So what's gonna have to happen is somebody's gonna have to pay money for the strap that got damaged on your tether.
Understand.
I'm gonna reinstate your previous bond where you were previously at home, right?
Mm-hmm.
And then they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
I really appreciate how Judge Simpson is treating mental health as a serious issue instead of just another detail to overlook. Most courts rush past it, but hey, is taking time to truly understand what's going on. This defendant cut off his ankle monitor because he's claustrophobic, yet he never even left his house. That tells me it wasn't rebellion, it was panic. You can see that the judge recognizes the difference between someone being dangerous and someone simply struggling to cope now. Yes, removing an ankle monitor technically counts as breaking a court order, which can lead to jail time. But instead of jumping straight to punishment, Judge Simpson is trying to understand why it happened. That's Ray. Many judges would have handed down a penalty immediately without any discussion. Watching him handle this feels like seeing someone carefully balance empathy and authority. And honestly, that's what true fairness looks like. It doesn't seem like this man had bad intentions at all. It feels more like he reached his limit and didn't know how to handle the pressure. Sometimes what's labeled as non-compliance is really just untreated anxiety or fear. What's troubling, though, is how the system seems more focused on rules and procedures than on actually helping this person get the mental health care he needs. What do you think? Is Judge Simpson handling this the right way? Or should the system take a different approach?
All right. Thank you, Your Honor.
Okay. Don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor, without necessarily violating a confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the tether agent if that arises.
Response.
We addressed this, I think, in the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. They would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office, so that the court would be apprised of what was happening. But the tether conditions, I believe, ought to remain the same.
Actually, what happened last time was the public defender came up on Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine, that's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk, just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Yates. right now.
I will be clear right now, Your Honor, what I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told and I made it very clear, we'll bring him in here. Because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request is for a tracking tether change.
Stop talking. You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Ms. Yagi, my chamber.
We're grabbing the joinery right now, Your Honor.
Your Honor, I'm very familiar with Mr. Peoples' case that the court wants to proceed.
All right. Ms. Douglas is now here on behalf of the people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make his bond in his new case match the bond with the conditions in his other case, so that he can be released, because otherwise he would be held on that. He'll be refitted with a tether on, he'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid, and all prior conditions are reinstated. And then we need a new date, so when do we?
Your Honor, my request.
Well, I got the confident, it's actually going to be October 30th.
Okay.
It's going to be our day, so. All right.
Thank you, Your Honor. May I provide the court with the order to undergo a forensic?
There hasn't been enough on this case yet, Mr.
I'm not.
Go ahead.
May I approach?
Yes.
Thank you.
What is this? No, that's the order on the other case. I'm sorry.
Might be tomorrow, but she needs to put the order on you.
Okay. Sounds good.
Okay. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're going to do it, right?
Yes, Your Honor.
All right. Okay. Thank you.
The real issue here is that the prosecutor doesn't seem interested in helping this man with his mental health struggles. It feels like they'd rather just lock him up and call it justice, instead of addressing what's actually causing his behavior. That approach doesn't solve anything. It just hides the problem for a while. If someone's struggling mentally, punishment alone won't fix it. In fact, it often makes things worse. Placing someone in jail without dealing with the mental health side almost guarantees they'll end up back in court again, only more unstable than before. It's common sense that when you address the root cause first, the rest starts to fall into place. Unfortunately, that kind of practical thinking doesn't always make its way into official policy. This seems like a rare misstep from McDuffie, who's usually more aware and balanced in her decisions. What really stands out here is Judge Simpson's reaction. He isn't yelling or losing control. It's that quiet, serious anger that tells you something's deeply wrong. Sometimes that kind of calm frustration says more than an outburst ever could. So, what does it tell us about the system when the judge seems to be the only one pushing for fairness and compassion? This case definitely stays some strong opinions. Let me know your thoughts in the comments. And as always, thank you for watching. Don't forget to like and subscribe. It truly helps the channel grow. Take care, everyone.